Okay. It's my pleasure and honor to introduce you all. Some of you may have already met with Attorney William Remery. He doesn't know it, but I tell him all the time, he's ACT's attorney. And we're so grateful for him being a part of our group. He is just fantastic. I want to read a brief bio. He was admitted to practice law in California in 1979. Mr. Remery has extensive experience in all aspects of family law, probate, conservatorship, estate planning, elder law, Medi-Cal planning, trust administration, civil litigation, and general transactional work. In addition to numerous complex estate administrations, his expertise includes prosecution and defense of wills and trusts. So without further ado, we welcome Bill Remery. And I want to say that he has helped several of members of our church. He's helping me with my trust. He's having to counsel me because I be trying to control from the grave. But we about to get there. But anyway, we do want to welcome you, Bill. We so appreciate you. We love you. We thank you for what you do for ACTS. And so now Kim is going to read a disclaimer. And after that, let's give him a warm welcome.
Yeah, so this presentation, just want you all to know this presentation is intended for general information only. It's not intended to be legal advice for any specific person or situation. Since every person's problems and issues are different, and since laws and regulations change constantly, you should seek individualized advice from a qualified elder law attorney before acting on any information provided during this presentation. Mr. Remery, please take it away.
Thank you. I appreciate it. I'm going to start by apologizing for my voice. I've been fighting a head cold for a week now, and I may have to interrupt this with a little coughing. I'll try to mute myself if I do. But I do have, well, here we go. There are two areas that I was asked to speak about employing caregivers and the issues that arise there. But I actually have two things that I would like to address today. And I will tell you right off the bat, one is really bad news and one is really good news. And so the question is, which would you like me to start with? Would you like me to start with the good news or would you like me to broach the bad news? Start with the bad news. Okay. So the bad news is about employing caregivers. California is one of the few states that actually has a minimum wage for caregivers. Most states and the federal government, in-home care workers do not fall under the normal wage and hour minimums. California does have it's called the Caregiver Bill of Rights, was the way it was titled when it was enacted, I think about 7 years ago. And it follows essentially this similar minimum wage rules for normal workers is usually 8 hours a day and 40 hours a week. That's considered a typical week. Ordinary, you have to get your minimum wage for those first 40 hours. For regular workers, anything over 8 hours a day or 40 hours in a week, you're entitled to time and a half, usually up to 12 hours, and then it goes to double time after 12 hours. Well, the rules for in-home caregivers are a little different. The normal minimum wage applies for the first 9 hours a day, not 8, the first 9 hours a day or 45 hours a week. And anything after that is time and a half. It never goes to double time, but it does apply time and a half. And then, of course, if you've worked during the week, your entire weekends are going to be overtime because you've exceeded your 45 hours in the week. Okay, so what is the minimum wage? California minimum wage is more than double the federal minimum wage. The federal minimum wage is about $7.50 an hour. California's minimum wage in 2024 is $16 an hour, unless you are a fast food worker, that's $20 an hour, and then they have some for nursing care, and they've increased the minimums for that. But for the in-home care givers, they fall into the normal overtime rules, which is $16 an hour. So what does that mean? If you can just get away with someone coming in, helping out, say, let's keep it just down to the 9 hours before we get into overtime. With 9 hours to get someone up in the morning, make the breakfast, make the lunch, make the dinner, clean up, help the person take a shower, and then they're not needed after the 9 hours. Then if you are the employer, in other words, they're not working for an agency, and you can get them to work for minimum wage, that first 9 hours, and you only need them during the week, five days a week, so we never go to overtime. That is $144 a day, $720 a week, $3,096 a month. So for $3,000, call it $3,100, you can get 9 hours a day, 5 days a week. Now, that means that for the other 15 hours a day and for the full weekends, we need family, or we need someone else to pick up that slack if it is someone who needs really 24-hour care. I do have a number of cases where they have a caregiver who comes in for half a day, 12 hours a day, and the family picks up the other 12. So what does that look like? Well, at 12 hours a day, 7 days a week, it comes to about $7,100 a month. That's minimum wage. No extras, no frills. And if you are in fact the employer, you're supposed to withhold state and federal taxes. You're supposed to pay your share of the FICA, the Social Security tax. The employee pays half and you pay half. There's an add-on. If you cannot afford roughly $8,000 a month, in addition to your other expenses, in addition to your housing and food and all that kind of stuff, you can't afford to have someone in your house for 12 hours a day. Now, I have a lot of people say, oh, but I have a live-in. She's great. Family has known the family for years. We pay her $5,000 a month, and she lives in. And since we're giving her a place to live and all of her food, we call it even. Well, the state calls that wage abuse, or wage theft is actually what they call it. If you have a live-in who is available, so let's say not often, but occasionally at night they have to get up and take care of the person who needs care, they get paid 24 hours a day for being available. Even if they're actually up handling things only a few hours a day after feeding and showering and doing those things, and then they kind of watch TV with the person for a while, and then they put them to bed. But they're available if someone needs to get up or needs to be changed or needs medication. They get paid 24 hours a day. And again, minimum wage. And I just ran these new numbers because I had the 2023 numbers, and they just bumped it up 50 cents an hour coming into 2024. So I reran my numbers to verify. And if you need 24-hour care and you do it with one person, it's almost $16,000 a month just for that one person, not counting the FICA, not counting workers' compensation, not counting having someone else come in for if they're ill or things like that. So again, I did have a case just this week. People came in and they said, okay, we're going to have this 24-hour care. And I said, whoa, wait a minute. Do understand what the cost is going to be. Well, they had $20,000 a month income between the husband and wife. They have cash flow. of $20,000 a month, they're one of the very, very few clients of mine who realistically could have in-home care 24/7. Okay, so what are your options here? First of all, I am discouraging everyone from from being the employer, trying to get away with this minimum wage and fit the pieces together. Where I am now defending three clients of mine where their parents have died. In all three cases, the person who was being cared for has died. And in all three cases, the former caregivers have sued the estate of the deceased. Well, one was a parent, one was an aunt, for all the missed overtime for the last 4 years. Now, in one case, it was that 24-hour live-in person. And when she was with an agency, and when at some point she came to my client, who was the son, and said, you know what, I've been working for this agency. I'm not happy with them. I'll work for you directly, and I can work a little cheaper. You're paying this agency more money. You can pay me less, and here's what I'm willing to do. And I think they settled at like $6,000 a month, plus place to live, plus the food. And I'm good with that. And my guy, okay, great. And you're taking care of my mom. Mom passed away. And she came back, and now she's suing for $500,000 for the last 4 years. That's the overtime calculated. That is the penalties, the interest, and the attorney fees. $500,000 for 4 years' work, in addition to having gotten $72,000 a year wages. And on her complaint, she has a very good chance of winning. I filed a cross complaint for fraud and what's called fraud in the inducement, in that she tricked my guy into doing this. She knew what she was doing, and how I know she knew what she was doing was she sued a former employer the same way. Now, on the complaint, I can't use that as a defense, because the law is the law is the law, and any attempt to get around the minimum wage is against public policy. They brought an action after I filed my cross complaint. They tried to get it thrown out, saying, hey, you can't violate the minimum wage no matter what. And I said, no, you're right. But if you win on your complaint, which you may well do because that's what the law says, my client's damage for that is what you tricked him into. That's the cross complaint. So if they don't win on the complaint, then I don't win on the cross complaint because I don't have any damages. But if they win on the complaint, that's the measure of my client's damages. And the judge bought that. He said, yeah, you know what? That sounds right to me. Had she not sued another employer previously, I don't think I could have raised that cross complaint. So I'm doing this to show you the kind of numbers we're talking about. It's not a nuisance. It's not, oh, they may come back and I'm going to have to pay them a couple $1,000s more. This is serious, serious stuff. So I've recommended, and the other piece of this is, if they're true independent contractors, then the minimum wage does not apply. But to be a true independent contractor, they have to have essentially an operating business. They can't say, I am a business of one, I am a caregiver, and I'm independent. I'm willing to work for this amount of money as an independent contractor. The law, again, because they don't want people trying to trick wage earners, trick employees into avoiding the minimum wage. So they build all these obstacles. And they say, if you're going to try to make out that the person you hired is an independent contractor, they have to have their own business, their own tax ID number, probably other employees, certainly other clients. If it's one person and one client, they're saying that's an employer. That's not an independent contractor. An independent contractor has different employees. If they're only working 9 hours a day for you and they want to work 9 hours a day for somebody else, they could have a business like that where they have multiple clients. So you might be able to structure something with an independent contractor, but it is so dangerous. And the potential result, if you're a homeowner, is so onerous that I have to recommend you go with an agency, which is more expensive, but they take on all the liability. They do the withholding. They have the workers' comp. If your caregiver gets sick, they have a person to fill in. If you hire somebody as the caregiver and the caregiver gets sick, you got to go out and find somebody else. You can't go to work that day because your caregiver isn't there and you don't have a backup. Whereas if you have an agency, they will fill that in. So if you have the money to support either round-the-clock care or at least extensive care at home, then I recommend you use an agency. So all of that is the bad news that I feel compelled to share. I'm sorry, was there a question?
No, they were
Okay.
like, that's enough bad news.
Okay. Okay, now, so unless, and if you're going to do,
Ms. Remery, do you want questions throughout or at the end?
no, I'd be happy to entertain them if right while I'm in the spot so we can keep the flow going, that's fine. If somebody has a question about this.
There is a question.
Go ahead.
So say for instance, I have a girlfriend who has a husband who has ALS. She wants to eventually bring him home, but she knows he needs 24-hour care. If she hires someone, even if it's just the basic 9 hours a day or whatever, basically she needs to sign up and get a DBA and have a business and have her EIN number. And she has to structure herself as a business just to have someone come in to take care of her her husband. Is that what you're?
So it's not the hiring person that's starting a business. It is if you don't want that person to be considered your employee,
Right.
It's the caregiver that's got to start the business. So if her girlfriend is going to come in, her girlfriend needs to start this business, and it might be a business she's interested in starting, and she should have probably more than just one person that she's helping, or maybe she gets together. Now, I have another situation. One of the 3 cases that I'm defending, it's 2 ladies who came in to care for a couple. And they shifted off. They came and went when they wanted. They made their own hours and stuff. And I'm saying those are independent contractors. And they did the same thing. They were with an agency, got them to drop the agency, and then they're doing this stuff. But they also had other clients because we have text messages saying, "Oh, I'm going to stay. I want so and so to stay an extra 3 hours a day because I've got this other client I have to meet." And so we were showing that they really truly are independent contractors. Notwithstanding that, they still did the same thing. They came back and sued. Basically, it's the house is a sitting duck. If you don't own your home, then, if they want to sue your estate after they die, I don't know what other assets you have, whether that's as critical to you. But if you have assets to protect, you have to be extremely careful with this because there is a firm out there, a law firm out there. And again, I'm not disparaging. This is a business. Their website is called caregiverovertime.com. And that is the only kind of case they handle. They handle nothing but caregiver cases because this law is such a slam dunk.
But
go ahead.
What if it's the latter? Say, for instance, the caregiver does not have their own business. It would be the person who needs them. They will then have to either set themselves up as a business, right? No. So basically just don't get anyone unless they have their own independent contractor's license.
They have to have an honest to God.
We need one person speaking for the recording, and so the people online don't get lost. Okay, Mr. Remery is responding right now. Okay,
yeah. So in that situation, the hiring person doesn't need to set up a business. The caregiver either needs to have a legitimate business of their own, or the homeowner is an employer. It's definitionally an employer, and you have to then follow all the employer rules. So, for example, I would tell them go to Paychecks or one of those services that does the wage withholding. You say, I have this employee. She comes in 9 hours a day, 45 hours a week. I pay her minimum wage, $16 an hour. Please do the withholding and stuff. And then Paychecks will say, okay, now you need to kick in another $650 for FICA and this stuff. And then they'll advise you, make sure you get your workers' compensation coverage, because if that caregiver is at your home and they're lifting your loved one out of bed and they screw up their back, you're going to end up supporting that caregiver for the rest of their life, unless you have workers' comp. If you have workers' comp, then that's the workers' comp covers that as the employer. Most homeowner policies have an occasional workers' comp rider on it, but that's usually like for the gardener or the maid that comes in. It's not for somebody who's there full time. So if you have a full-time person at home, you should go to your homeowner's insurer and say, I need to add workers' comp coverage for this in-home worker that I now have, unless you're using an agency. So either, my opinion, it's just too dangerous to be the employer and it's too much of a hassle.
Yes.
If you can't afford to hire an agency and you can't locate a true independent contractor, or when that independent contractor comes in, they may be too expensive because again, they're not working for free either. You need to think of an alternative. You may just not be able to afford in-home care. At that point, assisted living, they have what they call the 6-packs, where there's a small house, maybe 6 people. That's typically bedrooms that you can get your meals. They'll help you with your showering and stuff, but you still have to be more or less independent. If you need more than that, now you're at a higher care level with either one of those institutional board and assisted living or actual skilled nursing. Anybody else?
There's a Carlene, you have your hand up online?
Yes. Hi.
Hi.
A few questions.
Sure.
Is the Caregiver Bill of Rights the same as the Domestic Worker Bill of Rights?
Yes. Yes.
Okay. So, and so if someone is looking to hire a caregiver and there's this employment law, is there a particular website at the state that you would go to understand what, the kind of regulations are at all?
Unfortunately, all of those are set up for the employee. There's no
Okay.
real education for the employer. If you
Okay.
go to EDD, Employment Development Department,
Because
they
it's like
do
an
have,
employee.
they do have rules so that you could learn the rules, but
Right.
most of it is set up for if you have a complaint or if you are not getting this, it's all set up a protective for the employee who has traditionally been the abused one. You have to understand
Right.
where this law came from. It wasn't to make it impossible for people to have in-home caregivers. It was passed by the legislature in response to
Abuse.
a perceived and real problem, and that is many caregivers were abused. They worked as indentured servants. Maybe they got $2,000 a month and they never saw the light of day. They had no life of their own. They lived 24 hours a day for this person. They did as they were told. They weren't allowed to have, friends in, certainly no romantic relationships. They were indentured servants. That was the context. And oftentimes they were immigrants, sometimes illegal. So they felt they had no power, no ability to assert any rights. Under the caregiver provisions that have been passed, you can't even ask about status, about your legal status here. That's off the table. So that is no longer supposed to be a factor in whether or not anyone who's working in California is entitled to the minimum wage regardless of their status. So that was the context in which this came up. The thing is, though, it just made it kind of impossible now for most people to have in-home care. Now, there are, I won't say conspiracy theorists, but there are people who opine that the nursing home lobby was behind this, in addition to the workers, the really lower level workers lobby, because this devolved to the benefit of the skilled nursing facilities, because they're the only job in town now for people who can't afford in-home care. But again, that we can talk philosophy, we can talk law. Bottom line is, it is what it is. You can't do anything about it. You either comply with it or you have to find an alternative way of getting your in-home care.
So for those on the Zoom in the chat, I did put the Domestic Worker Bill of Rights. So you could see it from the perspective of the domestic workers, just so that you can know. So it outlines what's required.
Thank you. That's very
Mhm.
helpful. Okay, now, that was the bad
Remery,
news.
Mr. Remery, there's one more question in the room.
Go ahead.
Bill, what about your homeowner's liability insurance? Does that come into play?
It may cover your workers' comp if they get injured, but it will not cover a failure to pay minimum wage, which is a crime. Insurance does not cover crimes.
Okay, thank you.
Okay. All right. So after hanging all that crepe here and all the bad news, the good news, and there is actually a little segue in this, and I'll get to it in a minute. And that is as of January 1st of 2024. And if, incidentally, if you are from outside the state of California, or you're planning for relatives who live outside the state of California, you can tune out right now, because this is only applies to people in California. And that is that Medi-Cal, which is California's version of Medicaid, no longer counts assets.
Mhm.
So if anyone now can apply for Medi-Cal, whether it is community-based or long-term care Medi-Cal, and it is an income-only program. Basically, it is the Affordable Care Act Medi-Cal from the state website. You just follow it through now, which used to apply to everybody except for seniors and disabled people. Seniors and disabled people were under the old system where you could not have assets in excess of countable assets in excess of $2,000 and still qualify for the program. If you had more than $2,000, you just didn't get your foot inside the door. No reason to go any further. In 2022, in July of 2022, they increased that $2,000 allowance, that exempt resource allowance, to $130,000. Excuse me, $130,000. Again, this only applied to California. No one else got in on this. California asked the federal government for a waiver, saying, look, with $2,000, we've got people who are homeowners, and the home is exempt. But if you only have $2,000 in the bank, you can't keep your home. So we want to, it's just not realistic. So let us increase it to $130,000. That will let people keep their exempt resources, but they still have to show a need if they want Medi-Cal. And that held us for a year and a half while we waited to see if the federal government would give us a complete waiver so that we coordinate the long-term Medi-Cal program, for elders and for disabled, with the Affordable Care Act Medi-Cal, which never did count assets. If you were low income, everyone is supposed to have medical insurance. That's what the law says. Everybody's supposed to have medical coverage. And if you don't, you have to go to the state website and they will force you onto Medi-Cal if your income is low. Otherwise, they have other insurance alternatives, but they will make sure that you get an insurance policy. And they didn't care how much assets you had. So what California has done now is they said, okay, we want to put all of our Medi-Cal applicants in that same hopper. We want to follow that same pattern. Let's not worry about assets. Let's just look at income. Now, the reality is, because the income levels are so low in terms of qualifying for Medi-Cal, it doesn't help us a lot with community-based Medi-Cal, because to get community-based Medi-Cal, you can't have more than about $1,500 a month, but you can get share of cost Medi-Cal. So if you have extraordinary medical expenses, even if you have excess income, you can still get Medi-Cal with a share of cost and simply apply that share of cost toward your medical expenses each month, and all of your rest of your medical will be covered. So it is still viable, but not as much as the long-term program. Now, long-term Medi-Cal is, I always call it the big ticket item. And this is where that in-home care crossover comes. You can't, if you can't afford to have someone at home paying 24/7. Long-term skilled nursing care now may be viable where prior to January 1st, it was not. Give you an example. Prior to January 1st, you could have a home, one car, and then as of July of 22, you could have 130,000. Prior to that was only the 2,000. But that's it. Well, I'm sorry, there were other exempt resources. Your household furniture and furnishings, you could have IRAs and KIOs. They let you have those, and the mandatory annual withdrawals went toward income. So, but without getting into the weeds in this, basically there was a limit to what assets you could have. So if you went into a nursing home, they were private pay, and the average private pay rate's over $11,000 a month. So the same problem with getting in-home caregivers. Now I'm paying in a facility. Now with the lifting the asset requirement, you could have that extra home, maybe, you know, a cabin somewhere, or you could have the boat, or you could have half of, you know, 500,000 in an investment account. And Medi-Cal will not count those assets. You can still get on the long-term program, get assistance in a facility. They will look at your income and they'll say, look, that 500,000 in investments is spinning off 30,000 a year to you. So there's 2,500 a month. Plus you now have your Social Security. There's another $1,500, $2,000. So you've got 4,000 plus in income. We're going to apply that. We're going to give you $35 of that, $35 allowance for that. We used to call it cigarette money, but we don't call it cigarette money anymore in nursing homes. So you get that $35 allowance, which has been the same for the last 40 years. That's not in all the other numbers get indexed, but that $35 has never changed. So you get the first 35, everything else goes to the facility. So out of your 4,000 a month, we're going to give 35 to you and $3,965 to the facility. And now Medi-Cal is going to pay the balance. Even though you got the 500 in the bank, in the investment, you've got the little cabin and the boat next to it. That's brand new. Particularly if you have a spouse, that means we don't have to go into impoverishment planning to gifting things out or moving things from non-exempt assets into exempt assets. Now everything's exempt. All assets are exempt effectively. They do not count toward qualifying. Only the income that they generate counts. So if you have an asset that doesn't generate income, having it will not even affect your Medi-Cal. Now, with the other 49 states still at $2,000, I can't guarantee how long this is going to go or what direction things are going to take. For the time being, this is really good news for those who need care. It opens up a portal to get the services that you need, and you can now afford. Definitionally, you can afford it because if you don't have the income, Medi-Cal will simply pick up the difference. But that's at the skilled nursing level. Anything short of that, if you're in community-based, now the allowable income being only like $1,500, anything over that, you've got to spend down, not on just spend down. You have to spend it down on medical stuff first. And so it's not the be all and end all, but it is helpful. Now, the piece that goes along with this is about trusts. Prior to 2017, it did not matter whether you held your assets in a trust or hold them in your own name or you had a joint tenancy. If you received Medi-Cal after age 55 and you died, Medi-Cal looked to your estate to be reimbursed. So it really was kind of like a loan. Okay, they'll give you the services, but then if you own anything when you die, they want to be reimbursed. In 2017, they changed the rule. And they said, if you received any benefits after age 55 from Medicaid, which is California's, that's the federal name for the California Medi-Cal, the federal government says we have to look to your estate to be reimbursed after you die. That's what the federal law says, and we got to follow it. But the feds don't tell us what we have to look to for reimbursement. They just say look to their estate. So we are going to define a decedent's estate to mean a probate estate. So if you're holding your assets in a trust, we don't have to look at that. If you hold your assets in a beneficiary account where it's your name with your child as a beneficiary, that's not going through probate. So we don't need to look to that when you die. Well, at that time, of course, 2017, we were only looking at the exempt assets to begin with. Remember, one house, one car? Now that everything is exempt, theoretically, you could put everything in a trust and get on Medi-Cal, even with substantial assets. And when you die, there will be no claim against those assets. The reason for it, people are saying, no, that can't be right. Why would they ever do that? Well, the reason, again, goes back to this Affordable Care Act Medi-Cal. When the Affordable Care Act came into place and people started getting forced onto Medi-Cal because they didn't have health insurance, they came back to the legislature and said, hey, you know what? I just got a notice from Medi-Cal saying, congratulations, you're now on Medi-Cal. Incidentally, when you die, we're going to claim reimbursement. They said, wait a minute, if I go to Blue Cross and I get medical insurance and I use it during my life, and then I die, Blue Cross doesn't get to come back and get reimbursed for everything they paid for me. So what's this deal here? You're forcing me onto Medi-Cal, and now you're making me essentially borrow against my child's inheritance later. So that when I die, they're going to want to come back and be reimbursed. And the legislature bought that argument. They heard it. So what they said is, well, problem is, again, the federal government says we have to. So what can we do about that? How can we comply with the federal law and still not force people into a program they didn't want to be on in the first place and make it be a loan? And so they figured out, oh, the federal law just says estate. And we used to just define estate as anything that passed when you died. That means trusts, joint tenancies, beneficiaries, anything that passed when you died used to be what we called an estate. We're just going to redefine that. We're going to define it only as a probate estate. And in a swipe of a pen, they made this huge change in the recovery program, which now, so ever since 2017, for the exempt assets, the house, the car, we've always told people, look, get a trust, put it in a trust, and then you don't need to worry about a claim later on. Well, now that you can get on Medi-Cal regardless of what assets you have, we're saying put all of your assets in a trust. Okay. So this is all on the good news side. It may sound kind of tedious and stuff, but actually all of this is good news. It has opened up, and what we've been looking for all along, and we're still one step short of it, is incorporating all of the needs-based medical stuff as particularly for aging, along with what I call the hard medical stuff, which is the heart surgery, the brain surgery, all that major medical stuff has always been covered by Medicare and Medi-Cal. And it's always been available to everybody, regardless of, basically whether you have assets or not. And where Medi-Cal will pay, $100,000 to have an operation for a 90-year-old for a heart valve thing or something, they won't pay for $10,000 for in-home care, and they still don't. So that the in-home care, although they give a lot of lip service to wanting community-based services and wanting to keep people in their homes, we're not there yet. That's the one piece that is still missing. Lobby for it when you can with your legislators and come up with ideas. They do have pilot programs. They keep trying. They're usually capitated. They only have a certain number of slots. They have the waiver program, the assisted living waiver program, the community-based waiver program, where they will give you the Medi-Cal benefits as if you're in a facility, but supposedly in the community. But they're they're limited. They're limited, and there's only a certain number. We are fortunate that LA is one of the major counties that has this. Some of the counties don't have it at all, and it's not easy to find, and it doesn't cover everything you need, and it's still not covering somebody who needs 24-hour care. But it is out there. So things are moving in the right direction. As always, things move too slowly and not quite there. Donna, did you have a question? You're muted.
No, I didn't have a question. Just
Oh, okay.
stretching.
I'm sorry. I saw your hand up and it's just out of the corner of my eye.
Just
okay.
stretching. Thanks.
No, not at all.
There's a question in the room, Mr. Remery.
Go ahead.
You spoke of assisted living being those that are covered. What about memory care locked facilities?
So-
The hospital is trying to get me to do a hospital probate. No, hospital probate conservatorship. And they told me to stop the regular conservatorship. Why would a hospital do that?
I don't even know what they're talking about, a hospital probate conservatorship. So there are two flavors of conservatorships. Well, there's multiple ones. The basic ones are either probate conservatorship or a mental health conservatorship, which is under the Lanterman Petrus Short Act. That's where you might have heard of people on a hold, a 72-hour hold, where they are
Okay, keeping on that. That's probably why.
Okay, so that is initiated, can only be initiated by the county. It cannot be initiated by the family or by an individual. Only the county can initiate it. The family can take over after the county initiates it. It starts with the 72-hour hold. So a person goes into a mental health facility for 3 days, and that is usually because they've been acting out, or I had a client threw a chair through a gas station window and stuff, and so the police came, picked him up. He was clearly out of it. After 72 hours, if they've taken the medication, they level out, they just let them go. They unlock the door and they're gone. If that doesn't do it, they can hold them for another 14 days. And again, if then they take their medications, and I have some bipolar clients and stuff like that, and then they level out and then they let them go. It's just kind of a yo-yo thing. And so every few months they're going through this charade. But bottom line is, if that doesn't level out after 14 days, then 2 psychiatrists can certify that the person is gravely disabled or a danger to themselves or others. Then the county initiates an LPS conservatorship in Department 95. That LPS conservatorship is treated like a criminal proceeding. They're assigned a public defender. They're entitled to a jury trial beyond a reasonable doubt standard. Because if they are found to be gravely disabled, they can be confined in a psychiatric facility, which they basically say that's parallel to a prison. You get all the rights of a criminal defendant. It has to be renewed every year. It expires every year. It has to be renewed with the same protocol. You're entitled to a jury trial, etc. And then the conservator is given certain rights depending upon the level of severity of their disability. That's the LPS one. So the family, after the county initiates it, the family can step in and say, instead of having the public guardian, who is the default conservator in that case, instead of having the public guardian act, I will act as my son's conservator or whatever the situation is. Okay, that's the LPS conservatorship. The probate conservatorship is supposed to be for anyone who has a disability, mental or physical, where they can't make their own, either financial if it's a conservator of the estate, or medical if it's a conservator of the person, can't make their own decisions. They can't, appreciate the consequences of what they're doing, but they do not need commitment or confinement in a psychiatric facility. if they require confinement or need confinement in a psychiatric facility, that can only be done in an LPS conservatorship. Now, they used to be for a probate conservatorship. A probate conservator also could not consent to psychotropic medication. And so that was difficult because many of our disabled family members need some psychotropic medication to address dementia or some of these other issues where it's not like bipolar and stuff where the kind of psychotropic medication you're taking requires the same supervision. So the law was changed back many years ago now, probably 20 years ago, to permit a probate conservator to specially petition for, we used to call them dementia powers. Now they just changed the definition and they call it for major neurologic conditions. And so in addition to have your normal probate stuff, which is your placement, where you're going to stay and things and how you're going to eat and what kind of care you're going to get. That's the normal conservator obligation. They give you and making regular medical decisions about getting care. Do you need treatment for your diabetes? Should you have other treatments that for regular medical stuff? In addition to that, to treat a major neurological disorder, now a probate conservator can be given special authority to consent to that. You can't consent to shock treatment or things like that that's the LPS stuff, but you can have Namenda and you know, Aricept and all that stuff, and then some of the other things which are really to address anxiety. So whether it is an antidepressant or other anti-anxiety things, a probate conservator now can give that consent, but it's a special request on the petition. And when the doctor does his declaration of capacity, there's a special page that has to be attached to it saying, I've addressed this person does need this kind of treatment or needs to be in a secured perimeter facility if they're a wanderer. Secured perimeter does not mean a mental hospital. Mental hospital, boom, we're back at LPS. But if they just need a secured perimeter so they don't wander, a probate conservator can be given that authority as well, but it's a special thing you have to ask for. So when this hospital says, get a probate conservatorship, not a hospital conservatorship, they must be talking about an LPS, that this person is not a good candidate for an LPS because they don't need it. You can use a probate conservatorship, which is, first of all, easier to get. The standard is lower. Number two, it doesn't have to be renewed every year. It just goes on. And it gives you all the authority you need except for mental health, being placed in a mental hospital, shock therapy, and there's some other, and some of the medication you can't do unless you have an LPS. I'm sorry, that was a long explanation, but I was trying to give you where the split is on this. For 90% of anybody's needs, particularly if it's something to do with memory care or something like that, a probate conservatorship is just fine. That's all you need. You do not need the LPS unless the person is acting out so much that they do need psychiatric commitment, and you cannot do that with a probate conservatorship. Okay.
Yeah, question.
What if he's both? So he cannot be placed in a facility. He's been in the hospital, regular hospital, for over a month. He is violent. His Alzheimer's does not allow him to be cared for. He fights when it's time to get changed. It takes like 6 people to clean him. He can talk on the phone like nothing's wrong. But we've gone through 3 rounds of referrals from the hospital being sent to memory care and assisted living facilities, and they can't do it. And now the hospital is telling me, oh, we want to do the conservatorship. And when we do the conservatorship, we're going to give you a public guardian, and the public guardian is going to find him a place, because these memory care facilities will not accept him without conservatorship. But I tried to do conservatorship in January and they told me I didn't need it. Now they're saying you do need it, but we want to do it, you don't do it.
Well, again, if it is a regular conservatorship, we've done, a lot of conservatorships. In fact, I was on the panel of attorneys get appointed to represent proposed conservatees. I was on for many years. I'm not on now. But we don't do the the LPS. Because the county does that. They have to do it. It's prosecuted by county council and it's initiated by the public guardian. And now it could be that they do the conservatorship of the person using the LPS. And you can do a conservatorship of the estate using a probate. But that's if you don't otherwise have access to the assets and the ability to pay for his care and stuff. So you need access to his assets. So you need a conservatorship to get to it because you don't have a power of attorney and you don't have a trust or any of those other tools. That would be a reason to potentially have a split thing where you have a probate conservatorship of the estate and a LPS conservatorship of the person. But I see no purpose in having a conservator of the person in both courts. In fact, I'm not sure that the probate court would even entertain that because they say if you have an LPS conservatorship, anything you do needs to be over there for the person because they say what authority you're going to have for the different aspects of your life. They give you, I think there's up to 6 powers or 7 powers.
Okay, to piggyback on where she's going with this.
I don't know if they can hear you. You can speak up just a little
Okay, to piggyback on where she's going with this, what if the person has assets in 2 states? Because he's just relocated. And I know state laws are different from state to state. So if he has assets in another state, would what's happening here legal be affected with what's going on in Texas?
If he's already under a conservatorship here, there has to be kind of a handoff.
No, it's not.
He's only power of attorney here.
Okay, then no. So if he's in another state, you have to look and see what the laws are there because they are state by state. Many of them, they're not called conservators. They just call them guardians. For us, a guardianship means a minor in California. Guardianships are for minors, conservatorships are for adults. But in some states, they call guardians people over the person, and they call conservators over the estate. It's a nomenclature. It's just the way they name things. But what it requires to get there is absolutely state by state. California changed in the 1970s. Prior to the 1970s, that was before the LPS Act, the Land Rent Petter Short Act. Basically, if you were living on the street and you got picked up, or if you were odd, the family said, hey, this person's really odd and there's something wrong with him, you were in danger of being placed out in Camarillo and never seen again. You had no civil rights, no nothing. The family said, oh, doc, there's something wrong with this kid. He's, antisocial and this and that. You're put in there and some people were never seen again. Well, in response to that, that's sort of in the one flew over the cuckoo's nest, scare period. They came up with this LPS Act to build in civil rights for people with mental disabilities and to make sure that they were always in the least restrictive environment, that only the absolute necessary rights were taken away from them. And so each of these things were built in, and that's why this whole LPS system was set up along the lines of the criminal justice system to build in the beyond a reasonable doubt standard, the appointment of the public, public defender as the attorney, and the requirement of having to review this every year because they didn't want people being put in a mental facility and never heard from again. So now it has to be renewed every year. We need to look at that person again and see, have they changed? Now, are they taking medication? Has their condition changed to where there is no longer suitable? So that's sort of the philosophy of how we got there. In your situation, and other states may not be there yet, or maybe they've gone past this. Maybe they have a better system where the other state. So that you would need to talk to somebody in that other state.
Thank you, Mr. Remery. Susan, we have a question online.
Good afternoon. attorney. My dad is in a skilled nursing living assistant facility, and his primary doctor or insurance is through Kaiser. And the facility, they would want me to, I guess, swap out his primary care from Kaiser to their healthcare system, and I won't do it. And I just wanted to know, what are your thoughts about that? What is my what are my rights? And, just insight about something like that, please.
I thought that Kaiser generally has the facilities that they, excuse me, well, I thought contracted with them. And it was sort of a handoff from Kaiser to the facilities, but it was the same, essentially the same system. And what was supposed to have happened, and this is going back now 8 years or more, is this continuity of care program where the doctors are supposed to follow you so that you did not have that. We always had a problem with a doctor would attend to them in a facility, and then when they got really sick, they went to a hospital. It's completely different doctors, and there was no coordination between the two. So there was the continuing care between Medicare, Medi-Cal, and the assigned, because on Medi-Cal you get assigned generally to one of the care providers, and they were supposed to provide this continuing care. It was CCC was the acronym. I don't know what it is, continuing care something or other. But that goes back like 8 years, and my understanding is that it was supposed to be a whole team situation, so that the same doctors who are seeing you in the facility would also follow you if you had to go into acute care. So I would ask them about that. It's not an area that I get involved in, but I would definitely look into that to say, what about this continuing care policy that the physicians who see him in the facility should be the same physicians who will follow him outside the facility?
Yeah, I think that is how they, prescribe that to be. My dad had an amputation, and he does have to go back to Kaiser to, for the care, the follow-up care.
Okay.
And, he retired from the federal service. He has great benefits and all this. I just don't want it touched or tampered with. I don't want any problems if he, needs to go back to Kaiser for something else. And he will say from time, I want to go to Kaiser. So if something comes up, I don't want to get off that track and be into this system. And now he can never get back to Kaiser or what have you. So, maybe I just don't want to get caught up and think like, we've signed something and now all of a sudden we can't get back and there's a problem and I don't understand all of this and now I'm stuck. My dad is stuck. So
Yeah, you need to get clarity on that because, again, the Kaiser does work with facilities, and that's why they direct you to certain ones that they interface with. But the whole point of the exercise is to keep the continuity of care, continuity of treatment, so people don't fall through the cracks. And if they're trying to make you shift, say, look, moved from Kaiser to LA Care. That's another one. So some people get assigned to Kaiser through Medi-Cal and they follow that. Some get assigned to LA Care and things. You can say, no, look, I want the doctors on this panel. I want to go in this direction. But once you're assigned there, it should stay consistent, whether they're in the facility or out of the facility, the same care. You should be in the same care system. And so that things, again, don't fall through the cracks.
yeah, they say Kaiser would be secondary. They would be first, primary. But I said, well, if it doesn't matter, then keep Kaiser primary and you stay secondary. So, but he is in the facility. So I'll just have to look and talk more and just see. But because
Express what your concern is and see how they can address that concern.
Okay.
So if it is, again, he likes his doctors, or you don't want that gap there where he goes into a facility and, oh, they didn't realize that he was allergic to this or that, or they didn't realize that this has already been tried before and didn't work. And so they're gonna redo something that didn't work the first time. So you want that continuity so that you avoid those things. See how they say they're going to address that.
Yeah, I thank you. I have brought up some concerns, and when I give pushback, and I've said, my dad had to recently go to Kaiser not too long ago. And I said, I want him taken to Kaiser and to get him there. And they did, but I don't want to be feeling that I'm being bullied, or that's a strong word, not that, or just, I don't want that. If I want my dad to go to Kaiser, yes, you've been caring for him, but it seemed like to me, maybe there was a gap. And because I feel there's a gap, I want to make sure that my dad goes here. And they've, done it, but I don't want to be hassled or haggled with these feelings, but I will approach it from that. And I think that's kind of been some of it. So maybe that's why we've been able to, continue to partner and not have no pushback when I say I want my dad to go to Kaiser. And so, but I need to explore it more and talk more. So this is very helpful. Thank you.
And please do be an advocate. Everybody needs an advocate. And this is where people sometimes get confused and they think, oh, if I complain or something, then it's going to be taken out on my loved one, or somehow they're going to be disadvantaged. That's just not true generally. I mean, so you could have, some individual person be nasty about it, or, something, but I've been doing this for 45 years and I'm telling you, it is a squeaky wheel system that the people who get the services first are the ones who have
Yeah.
loved ones out there who are holding people's feet to the fire, or at least letting them know that you're watching.
Yes.
Yeah.
So
And
you
that has
visit,
been my saving grace. And we like the facility very much. It's a very good facility. Work well with all areas of the social workers, the nurses, all of them. But, I did have a concern, and with not meeting the primary doctor, which my dad's been in there now over 2 years, and we're in there all the time. So I'm like, this is, asinine. I had to tell the doctor, like, if you had your loved one in a care and you never met their doctors, what do you think? What would you expect? I said,
right.
I know all my other dad's doctors. So, I've been talking to him some, but yeah, we do like the facility. We have really no complaints with the facility, and I'm grateful because one of the nurses actually went against policy or whatever to share this particular facility, because I did not want him in track with another facility, and I advocated, and I am grateful for that, because one facility he was only in for 6 days and they drugged my dad up so bad
Mm.
that it was horrible, and I had to get him out of there, and that was in Santa Monica, which you wouldn't have been expected that. But he's been here, and this is a great facility. And so I'm grateful for that. I really am. But because it's like you're David fighting Goliath, the system. You get in the system and you may not be able to come back, go in the dark hole. And I just don't want that, so I'm just suspect about things, and I have to kind of stay on my guard. But I do work with them, and I express my concerns, and I'm very, like strong will about, my dad's going to keep Kaiser, and we'll work with the doctors here as well, but we're never going to take that away. So,
Well, again, never be bashful about expressing your concerns, but don't be chintzy on expressing your gratitude. So
yes, no,
when you
yeah,
see
I
things,
am.
when you see things that they've done right, pat them on the back. And,
Yes.
and Valentine's Day, give them the box, at the
And I
nursing
do.
station.
I
Okay.
do. Very much
So,
so.
so you want goodwill in general, just so they know that you're not just a completely unreasonable person, but that you're not a pushover, and you
Yes.
don't take no's to be ignored. You're not to be ignored. And again, they have a certain amount of time and a certain amount of work that they can put in. They're going to start with the people are looking over their shoulders. So the person who has loved ones coming in any time of day, any day of the week, they're the ones generally who are going to get sort of the first service, the first food fed, the first everything, because they know they're the ones they're going to get criticized, because these people may show up anytime and complain. Whereas the person who either gets no visitors or that, oh, it's only every Sunday afternoon, well, then the other 6 days, they're a little further down in the train, but come Sunday afternoon, okay, let's get him ready to go because we know his daughter's going to be coming around. And again, it's a cynical thing to think about, but it's just practical. That's the way the world is. It is a squeaky wheel environment for, in these care facilities. And again, it's not the day worker there that it really is their fault. It's just they don't want to be criticized, and they only have a certain number of hours in a day, so they have to prioritize one way or the other. So which way are they going to prioritize? Well, how are we going to get less complaints? So you be the one that they want to cater to.
Yeah, my fear was like, if I don't go along with the program, like, will they kick my dad out? That is my fear. And I'm just like, ugh,
No, that doesn't happen. No, generally that they'll accommodate. Now, if they say, look, the kind of care that you want, we can't deliver. So if you want that kind of care, we have to move. Because we do run into that sometimes where they just don't have the capability. They don't have the staff and the capability for people who have major physical requirements that they can't accommodate. So yeah, the person's in bed too long. They can't get them up. They can't do, well, okay, they don't have the therapy set up and stuff that is necessary. Maybe you do need a different facility. But if it's just a matter of they don't bother. No, you raise things. Look, he needs to be out of bed at least twice a day. He needs this, he needs that, and they'll get it done.
thank you so much. Thank you.
Anybody else?
Thank you, Mr. Remery. We do have another question in the room.
Go ahead.
Oh, I'm sorry. There's a question behind you before you.
Thank you, Mr. Remery, for this invaluable information. I'm Denise Davidson, and I have two questions. The first question is in terms of state to state in-home care. If you have a loved one that's 6 months in state and 6 months in their home state, are you eligible to apply for in-home care for the 6 months that they are out of their state?
Excuse me. I have not had that situation, so I honestly don't know. You have to declare a residence somewhere. So I'm not sure whether it depends which one is your resident state. Otherwise you're essentially visiting. So I'm not sure what you would have. Now remember, all that stuff I went through, all the bad news stuff at the beginning was with the California Act. Generally, federally, there's no minimum wages. So there are different considerations potentially in another state about what care you can afford and how it can be delivered. But as far as your question about if it would be a different program in each state. I don't know if you can just go on a program for 6 months and then basically say, now suspend it for 6 because I'm going to be out of state. I haven't.
Like you would be deciding to do one state or the other. So the state is very and they don't have in-here home support care for family members to even get compensated. So that's just the thought that we have to make a decision. The other question that I have is in regards to a family. You have one sibling that's the executor of the estate and one family member that's the caregiver. Does that rule out the probate conservatorship for that person that's the caregiver?
No, one has nothing to do with the other. So when you say they're executor of your estate, I'm assuming you mean trustee of the trust or under power of attorney? Okay.
Yeah.
So the financial piece of it, what we prefer to do, rather than conservatorships are rather onerous. They're time consuming, they're expensive, they're a hassle, and you have to keep going back to court and stuff. If you have a good trust and or a good power of attorney, financial, you don't want a conservatorship of the estate. The trustee handles what's inside the trust, and the person with the power of attorney handles things that are outside the trust, like an IRA stuff can't be inside of a trust. So with the power of attorney, you draw money out of the IRA and then you give it to the trustee inside the trust to pay the bills inside the trust, whatever. In fact, usually it's the same person. We name the person with the power of attorney as the same person as the trustee. So that coordinates, consolidates the financial stuff, and we don't need a judge looking over it. We don't need court-approved accountings and all that expense and mishigash. The conservator of the person is the one who makes medical decisions and placement decisions. If you have an advanced healthcare directive, that person with the advanced healthcare directive can make those decisions. They don't need a judge for that. So we try to avoid a conservatorship by putting those two things in place well in advance of need, while the person still has the capacity to sign those things. If you wait too long and they drop below the level where they have the capacity to sign them, now you're out of luck. Now you're going to court for a conservatorship. But whenever we do an estate plan, along with the trust, we do a pour over will, we do a power of attorney, we do an advance directive, all that stuff is to keep you out of the system.
And this would be a family that I would refer to you because it looks like it's some inappropriate behavior with the finances from one sibling to the other. So I was referring them to you.
Now that's a that's a different issue. If you think, someone who is in charge of the finances is not handling them properly, then if it's a trust, you bring the trust under court supervision and say, hey, that trustee needs to do an accounting because he's running away with the funds or whatever. If there is no trust, then you probably are looking at a conservatorship, because the person with the power of attorney, who's really just acting in the individual's name, power of attorney gives you the right to sign somebody's name. So if the person is just acting under a power of attorney and again is not handling the finances properly, then you may be bringing a conservatorship. Potentially, once a conservatorship is in place, you may have to bring a petition for elder financial abuse. That would be unfortunate, but that's one of the remedies if someone has taken advantage of someone's finances, to try to recover them. And hopefully you can recover. Hopefully there's still something left. The problem is when many of these cases, the no goodnik who abused the elder financially has blown the money. And so, yeah, you get a big judgment against them and get their hands slapped and have this finding that they're elder abusers, but you never get the money back. You can't get blood from a stone.
Thank you. In this case, there is something still left, so I think it would be worth it to move forward.
In this case, there is something still left, so I would think it would be worth it for that sibling to follow through.
Thank you, Mr. Remery. Susan, there's an ask in the room for the facility your dad is currently in.
It's Country Villa, LA Rehab downtown. The surrounding area is not that great, but it's a great facility. They do lots of student training from the hospitals, but usually Saturday and Sunday is about 25 students in there, and it's a great facility. That doesn't mean it's perfect, but it is a good facility.
Is it assisted living or memory care?
No, it's a skilled nursing living,
Skill, okay.
living assistant.
Thank you, Susan. Are there any other questions in the room or online? Question?
We have answered this already.
I have a living trust, and I'm just wondering, the house is in the trust. Will we have to do anything for our daughter to take possession of that house? We have one house that's not in the trust, and I know you told me at one time, do not put it back in the trust, because if we put it back in the trust, then the property tax would like triple. So what do we do with the house in the trust? I think with the house outside, because it would just pass down from my husband to our son. We'll pass, like something happens to me, it passes to my husband, or something happens to my husband, it passes to me, or something happens to both of us, it'll pass to our son. But what about the house in the trust? Do we need to do anything about that?
Okay, I was getting a little bit of echo. So you have one house in the trust.
Correct.
I can't think of any reason why you need to do anything with that. As far as the property tax piece of it goes, I think we're talking about Prop 19, which is now when you transfer assets, even parent to child, which used to be exempt. We used to be able to transfer from parent to child and they would not reassess. That's no longer the case since April 16th of 2021. Under Prop 19, a transfer from parent to child still is reassessed just like if it was going to a stranger, unless it is the parent's principal residence and will be the child's principal residence after transfer. If those two things are correct, you can still transfer it over and maintain your Prop 13 base until the child moves out. If the child ever moves out, then it gets reassessed up to fair market value again. So, but at the second house, which wouldn't be the principal residence, any transfer of that is going to require reassessment. Now, that's except for the normal transfers, spouse to spouse doesn't get reassessed, and into or out of a trust does not get reassessed if the person transferring it in is the settlor of the trust. So it's a pass-through. It's like you can carry it in your left pocket or you can carry it in your right pocket. But if it's already been transferred to the son, and now you want to put it back in your own trust, that's child to parent. It's going to get reassessed. I don't know if that answered your question.
It answered my question. So if our daughter were to, so at this point, we can't put our grandson within the trust that it would pass down to him after the daughter, correct? Because it would still be the same thing as Prop 19, that he would get reassessed if he didn't live in the property.
That's correct. Plus, you can't skip a generation. So if your daughter is still alive and it's your daughter's child, assuming that your daughter would live in the property, you'd have to give it to your daughter. She lived in it. Then if her child moved in, then she could pass it to her child. And the two-step, you could keep bootstrapping in the Prop 19 exemption. But if there's any lapse anywhere in that, either it's skipping a generation or it is not the principal residence on both ends of it, it's going to get reassessed.
She said, thank you.
Thank you.
Okay.
Anyone else? No. Anyone else in the room, online?
I've exhausted everybody.
No, this has been so helpful.
So helpful.
So
Thank you
helpful.
So much.
Let's positive comments in the room.
Okay, great. Well, listen,
We want to thank you so much, Attorney Remy, for your time today. Everyone online, I did put Mr. Remery's information, his website in the chat. If you want to reach out to him, you'll let him know you're a friend of ACTS. And in the room, his information is on the board. This session was recorded. The link will go out today, no later than tomorrow, as well as the link from last month. My computer died on me, but it's back. So we want to thank you so much, Mr. Remery. You're welcome to stay, or if you need to exit, we absolutely understand, and we hope you feel better.
Thank you so much. I appreciate it. It's nice meeting you.
Thank you. Thank you so much.
Bye-bye, guys.
Thank you.
Okay, let me stop the recording.
No, please.